And I paid kind of for what you did at that time. That may have been a year or 2 years ago. This case has been in existence since 2016, and we're getting towards the court has admonished me that it will the time will run out on the case by November. It's scheduled for trial in June. Where I am at is through discovery, I added an additional defendant to the case, which is a corporation, which is the person that hit me was actually working the day of the accident. Mm-hmm. And I'm trying to determine whether he was working for the company that he was normally employed for. According to the current discovery, he was not only working, but he was at lunch at the point in time when he hit me.
And this happened in California?
Yes.
Okay, you're going to want to look up the coming and going rule. If he was at lunch, I don't know if he was considered to be on the job. All right.
Hang on a second. Let me make a note. Coming and going. Okay, hang on. I thought, because where I'm at is I'm trying to subpoena records from the company. The company is kind of hiding. It's a California corporation. And there is a methodology, I guess, of serving a subpoena through this California kind of corporate registration.
You have to serve the registered agent for service of process.
Hang on. Serve.
Unless they have an attorney, serve it on their attorney.
Serve registered agent for what was that?
Service of process.
That will be agent for service of process.
Is there excuse me. And I think I've is there a kind of instruction set for how to do that that's readily available somewhere? I think I downloaded one and was trying to work from that, but it wasn't clear how to do that.
Not sure what you're referring to, but you can find the agent for service of process is listed on the website, on the California Secretary of State website. And then whatever document you're preparing, you serve it, preferably through a registered process server. It sounds like in your situation, because you're proceeding in pro per, they're probably going to give you the runaround. So I would use the more secure service of a licensed registered process server.
Okay. And again, is there kind of a template available that I can download so I can make sure that I'm doing?
This is not a template. This is a process.
Okay.
This is it's the process of serving documents on a party.
Okay.
It's a party. What are you trying to serve again? A subpoena?
A subpoena of records to verify that the individual that hit me was actually working for the corporation the day that he hit me.
I don't think it would be a subpoena that you would need, since it's a defendant. All right, you're serving this on the company, correct?
Yes.
They're a party, so you just need a party. You just need discovery.
Okay.
Yeah. Have you done discovery?
Yeah, I've done discovery, but I added the corporation as a defendant at the end of last year.
Doesn't matter.
Until and COVID kind of interrupted things for 2 years until very late. They were the defendant was denying answering discovery questions. And finally, it was disclosed that, and in fact, the defendant has had a stroke. So he's not kind of medically sound. But his daughter disclosed that, oh no, my dad told me he was working for on the day he hit you, and he was at lunch at the point in time because it was early in the morning. And so,
well, I don't know why you would serve this. Yeah, subpoena is for a third party. Just serve regular discovery. If they have they answered.
No, and the company is hiding. It's a California corporation.
Have they been served with? Have they been served with the complaint?
Yes.
Proper service.
Yes.
So you can now serve discovery.
Okay.
Regardless of if they answered or not. I believe 10 days after the service of a complaint, you can commence discovery.
Okay. You wouldn't use kind of standard interrogatories. You'd have to do a kind of specific question line about this particular individual and his employment. Wouldn't you?
You may be right. I would take a look at the form interrogatories. Okay, see if there's any applicable. I would serve them with both form interrogatories and then also special interrogatories, more aimed at the information you want about the employee. Okay.
Yeah. Okay.
And also
and
also request for production of documents. I would request the employees and request the employee file, and you'll get objections. All right. If they do respond, if they don't respond, you'll have to motion to compel. All right. Regardless if they answered, if they don't answer, I mean, you can commence discovery, but if they don't answer, it's not likely you're going to have compliance. You're probably going to have to motion for default. It sounds like they're not answering the complaint.
Right. Yeah, they've.
Have you communicated with anyone through this company?
Well, we served them with proper service, but they didn't respond. They have never acknowledged that they were served, and virtually the way we served them was to slide documents under the door of the chief operating officer at an office that he's never at.
Okay, hang on. I want to make sure that we're sharing on the live stream as well. Chelsea, do you think you can troubleshoot that to see if our conversation is being live streamed? Just so you know, also, Mr. Bush, so there's no confidentiality. If we want to get into specifics, we should coordinate a private consultation. And there's also ways I can be of service for you throughout the process without being an attorney of record, because it sounds like you're quite entangled in the matter already. Do you have a trial date?
Yeah, we're trial date is in June of this year.
Who's your other defendant? Who's your other defendants?
The individual that hit me. Which it's an individual, private individual.
Have you asked him? So, what information are you trying to get from the company? Because what information can you not get from the employee? It looks like you're moving toward a motion for default here. Okay, I don't know. You might be wasting your time with this discovery issue. The information you may be able to get through the employee. Okay. Sounds like he has been responding, but you said he's decapacitated right now. Is that what you told me?
Yeah, he's somewhat decapacitated. But he's very reluctant, or had been very reluctant, to kind of be forthright. And the law firm that is representing him has, since inception, kind of been straight arming me with regard to discovery. It took me a couple of years to finally get to the point where, oh, it was admitted that, oh, he was working. And so I then am trying to determine if he was working for the corporation, if they would have liability coverage that would be applicable to him.
Absolutely. Absolutely. Well, look up the coming and going rule. On a lunch break, that's a tough issue. I don't know where the law stands on that. Sometimes it's back and forth, depending on the interpretation of this coming and going rule. So look that up. I think what information you can get from the employee as much as you can, try to get some discovery responses. I think you have enough. It sounds like the court has already allowed you to amend in the company.
Yep.
So you have them in the complaint. You've served them with the complaint. They have a duty to answer. They have not answered. You can go forward with doing discovery on the company. I doubt you'll get any response. I think you're moving toward a default. I think you'd be safe and secure to serve discovery on both parties, the employee and also the company. It's not a subpoena to a third party. They are now a party to the complaint. They've been served with the lawsuit. Taken in, without having really looked at that service. All right. Because they probably will dispute service at some point. I don't know what type of service it was. Was it service on the registered agent?
No, it was serviced on the CEO of the corporation.
That's fine. And was it served by a process server?
It was served by a private individual, but it was proper service.
I don't know. Did they submit a declaration and everything? If they're not a registered process server, yeah, I get what I get what you've done, and it's all legal, but it's not. There's different degrees of service. There's there's strong service, and then there's service that could probably get set aside. And I think in your case, without it being a registered process server, it could possibly get aside depending on the declaration of the individual. Did you submit a declaration describing the service?
Yes.
Well, I'd have to look at that as well. So, I mean, you'd have to examine the service, all right, how it was done, if it was sufficient. The fact that it's not a registered process server, I'm sure they will use it to their advantage. They're just going to push you through the process. You didn't originally name them in the complaint. They'll probably, I don't know what their legal tactic or what advice they're getting, but they may just force you to go through the default process, which could be a relatively time-consuming process. You think about it now, you have to motion for a default. That's like 3 months. It's setting it back. A lot. You weren't aware of the company only until through this litigation, correct? You found out?
Right.
I mean, that's fine. They're still probably forcing you to go through the default process. I would contact the company. Do you have email contact, or have you been communicating with anyone with the company?
No email contact. And they again, the only way that we have found them is to the CEO of the corporation has offices in Los Angeles.
Have you looked them up on the Secretary of State website? I mean, you must.
Yes, it's actually a reasonably large corporation.
I'm sure. So, who is their registered agent for service of process?
I don't know that off the top of my head, but I can look it up in the documents that I've gotten from the Secretary of State.
I would also serve them again with the complaint. Okay.
And use a registered process server?
Yes. Even if it's the agent. All right. Um, the agent has a legal position to accept legal documents.
Okay.
They're licensed by the state to accept legal process on your behalf. Every company that's formed in California or does business in California must have a registered agent. Now, your service, I'm not saying is invalid, but it is challengeable. One is not against a registered agent for service of process. It's against an officer of the company, who we believe is the CEO. That we don't even know what his position is. I'm sure you're more informed than I, obviously, but we still don't know. I'm just saying that service is not as strong as a registered process server on the agent for service of process. Do it by the book, okay?
Okay.
There's different degrees and strength of service. So go through the licensed registered individuals who can do service, and then file that proof of service again with the court.
Okay.
You want to do everything with the court on the record to show that you're going in clean hands, good faith. Okay.
Okay.
And put it on the record. All right. That's the public record. You're summoning them to respond, and they're not. That would strengthen your likelihood of obtaining a default. But defaults are easily set aside. So it's going to be a process. You've already spent, 4 years? It's probably now going to be another 2 to 3 years dealing with the company through the default process, default set aside, and then litigating from the beginning all over again.
Yeah, and the court has told me that in November, the timeline on the case will end and they will dismiss it. If it's not tried by that point in time, the judges said, no, it's going to be dismissed. Because the original accident happened in June of 2016.
I understand. I'll say this. Okay. Yeah. You there's a right to a speedy trial, but that's your right. Okay. So then say, well, don't give me a trial date. Where's your trial? Have you been assigned a trial date?
Yep.
All right.
June.
Well, then,
current trial date is June of this year.
keep your trial date.
Okay.
You want your trial date. And that's even more reason why you should serve this company again. And
Okay.
let the court know you're going in good faith. Look, I don't want to move my trial date. I don't want to lose it. All I'm doing is trying to get these parties to answer.
Okay. Thank you very much.
Chelsea, can we just troubleshoot this? Are we live stream on the platforms? And how are we presenting?
Well,
It should be the Zoom screen.
that's something we can further figure out. What I'm seeing currently right now is it's just a view of your video.
Yeah.
We'll further troubleshoot.
Yeah, it should be integrated and synced with the Zoom. Yeah, I'm not integrated, right? I think I have to do a share screen. I'm not too sure. Anyways, yeah, because we do have people logging in to view.
Yep.
We're live on Facebook, LinkedIn, Twitter. We do this live as well, Dan. So again, more reason why we do not get into too specific facts.
Specifics.
Yeah, and that's okay. We speak process, and that's fine. But any other questions?
No, that's a broad, current kind of discussion. So I really appreciate that. I have been, since the inception of this case, looking for a lawyer who would, because I'm out of my